Welcome back. I know it has been a very full day, and I appreciate your attention. And before we leave for dinner tonight, Tripp is going to set up what we'll be talking about later this evening. But before we get to that, we are going to be working through some of the legal issues, because as you know, you cannot engage in this work without considering what's important and what's current related to the legal issues that we must deal with on a day-to-day basis. Floyd Jennings has the record service time on the committee. He has been serving with us for 35 years, since 1983. Yes, so he is a retired elder and a member of the Texas Annual Conference. Houston, can we get a shout out? Yay, all right. And so I asked him, I asked Floyd, how would you like me to introduce you? And he said, just say you found some peculiar guy walking along the highway and that's what you needed today. So I said it, and here's Floyd. He's a peculiar guy, and he's a very knowledgeable guy, and I look forward to what you bring to us today. Thank you, Floyd.
I have the unenviable task of trying to keep you relatively attentive, and only relatively attentive before dinner. I do not know how that's possible. I told someone at lunch that my problems in life started when God and I were in kindergarten together, and she was always better than I, and I have developed an inferiority complex ever since. But this seemed to be the wrong group with which to discuss that. So I've decided I would move on to something more relevant. Now, I have good news and I have bad news. The bad news is that we're going to have to talk about some issues that are probably among the most soporific to which you will be exposed in this experience here in Dallas. The good news in that is that whatever happens in 2019 or in 2020, everything I say will be applicable. So let's start out with some things I'd like for you to keep in mind, and among which are, what, if anything, does this presentation raise for me? And secondly, what issues may affect the church? And thirdly, what have I would have wanted to hear that I did not? Now, I need to have a disclaimer, and the disclaimer is quite simple, that this presentation is not intended to be, nor should it be construed as legal advice or supplanting consultation with your chancellor and or GCFA legal services, or consultation with your own bishop. The opinions that I represent here are my own, and some wag said, Jennings, have you ever had an opinion you were reluctant to share? So with that in mind, we're going to talk about three issues, really, and they have to do with the liability for the church with a plaintiff who is a candidate or clergy, liability for the church with a third-party plaintiff, and we're going to talk about liability that may accrue to MASs in the legal sense. So let's dive in. And this is not going to take long, but I want to stop so that we'll have opportunity to talk about this in more detail. Very specifically, the question is, does the liability attach to an annual conference both for the measure, for the methodology, the procedure, or the content of a psychological evaluation of a candidate? And the answer, simply put, is no. You could very well ask your candidates to stand on their head in the light of a full moon and recite the 25 articles backwards. And they could say, well, I might be able to get through the 25 articles backwards. Let's see, number 5 is, the scriptures contain all things necessary for salvation. What is not to be found therein or proved thereby is not to be considered an article of faith. Now, let me see if I can say that backwards. And you could say, well, can you stand on your head? And they say no. And we say, no, too bad. We only take people that stand on their heads. And they would say, that's ludicrous. And you say, it is, but that's the way we do it. And they would have no recourse. That also means that HIPAA, Title VII of the ADA, the EEOC, age discrimination evaluations do not apply to clergy evaluations. Now, I'm telling you this in advance, and we'll go ahead and look at the specifics. Now, for MASs, the question is, to what extent do MASs have liability for conducting evaluations of clergy candidates? And the answer is a lot. What competing roles, if any, exist? There are assessment issues, both legal and ethical, special competencies for ethically and racially diverse populations. So here's where we start. Watson versus Jones was an 1871 case between two congregations that I believe were in Kentucky. Subsequent to the Civil War, they split on the issues of property. And they were fighting about this for 30 years later. And the Supremes, all 9 of them, said, the law knows no heresy and is committed to support of no dogma or the establishment of no sect. This is based on the Establishment Clause of the First Amendment. Or more specifically, they said, it would be a vain consent and would lead to the total subversion of such religious bodies if anyone aggrieved by one of their decisions could appeal to the secular courts and have them reversed. And that has been the fundamental principle that has been with us now for more than a century. So how does this translate into evaluations? Well, very specifically, there's no liability. And the ADA or Title VII do not apply. And civil courts do not resolve ecclesiastical disputes. The basis of these court decisions is that there is a ministerial exception. And it arises out, as I suggested, of the First Amendment and the free exercise clauses. It has the effect of also exempting the church from the application of any subsequent statutory rules that would otherwise affect pre-employment evaluations. Ordinarily, an employer cannot discriminate on the basis of age. There are a host of rules appertaining to the kinds of issues which you can and cannot raise in employing secular individuals. Now, the issue here is this exception we're talking about with regard to clergy applies only to clergy and those engaging spiritual functions of the church, and I'll give you an example, and not to lay employees. So if you have a janitor who says, well, I had an injury in the service and I can't really walk well, but with any reasonable accommodation, which ought to set you off immediately, you hear those words, I can function in this role, then they're entitled to that. Here's the case in the Baltimore Conference. Minker versus Baltimore Annual Conference, is a 1990 case. We cannot imagine an area of inquiry less suited to a temporal court for decision. Evaluation of the gifts and graces of a minister must be left to ecclesiastical institutions. Down the street here from us, where we are right now, in Hearst, there was a young woman who had come out of the Baptist tradition, was coming into the Central Texas Conference. See, Hearst is Central Texas, isn't it, Kathy? She was an associate, and she was requesting extended family medical leave under the FMLA. And the church said, we can't afford to do that, to keep you on leave for a period of time. And she sued. And the court said, get out of here. We don't care. The court said the fundamental right of churches to be free from governmental interference in their internal management and administration, in effect, shall not be abridged. Or there are several other cases: McDowell versus Calvin Presbyterian Church, Serbian East Orthodox Diocese for the U.S., Lewis versus Seventh-day Adventists. Well, that was an interesting one. The young lady was a PhD and wanted to be appointed to some church-related counseling effort, and were complaining about the fact that there was discrimination, sex discrimination, on the basis of salary and a number of other benefits. And the court said, we don't care, because this is a clergy position. Now, this extends. John, if somebody's here from Louisiana, you may remember this case. This is Starkman versus Evans. There was an organist in the Louisiana Conference who had a host of medical problems and bad knees and diabetes and some other things, and said, I just need to have some reasonable accommodation for my plethora of medical problems. And in that case, the court said, what do you do? And concluded that her services as an organist were essential to the conduct of worship and an ecclesiastical activity. And although she was not ordained, she would nonetheless enjoy the benefits of clergy for purposes of this lawsuit. And so she won. And there was a great quote from, this is explicated in Catholic University. It had to do with a person that was employed by the Catholic University. And the courts are trying to articulate that anybody who is involved in an endeavor which is intrinsically supportive of and related to the activities of the church will be, for this purpose, considered as clergy and eligible for the ministerial exception. The first time this came up was in McClure versus Salvation Army. The First Circuit articulated the ministerial exception to employment discrimination claims and held that the provisions of Title VII to the employment relationship between the plaintiff and her church would result in an encroachment by the state into an area of religious freedom which is forbidden to enter by the principles of the Free Exercise Clause. Congress shall make no law respecting the establishment of religion. And so I would say then that exception would not apply to persons whose duties are not intrinsically religious and integral to the religious functions of the church, janitor, secretary, and they may well be covered by Title VII or the ADA, by EEOC, or any number of other statutory rules. Now, what this does not mean is that it doesn't mean that the church is not liable when there is a third-party plaintiff. That is, somebody out there who has been aggrieved by the actions of a clergy person. But these cases go every which way. Now, we would have said before the advent of the scandals regarding sexual abuse in the Roman Church that it was, it could go either way. But the sentiment in the country is now holding clergy to an exceptionally high standard. So negligent hiring or retention claims could possibly and very likely may prevail, as well as other torts. There was a case in Colorado, DeStefano versus Graby, and a clergy person, a counselor, was with counseling. A couple became sexually involved with one of the partners in that marriage, and the court held that he was subject to secular law when providing services that were essentially secular in nature, namely marital counseling. Now, there was another case called Bladen versus First Presbyterian Church of Sallisaw, Oklahoma. I don't know if there's anybody here from the Oklahoma Conference or not, but they were Presbyterian. And in that case, Oklahoma said, well, we're not going to recognize clergy misconduct as a tort in our state. We're just not going to do that. But the point is that in the years subsequent now, it has become such a hot topic that it is extremely troubling, and Missouri knows that very well. Central Texas knows that very well, because we've had claims that have been settled in both of those annual conferences. On the other hand, MASs face a very different scenario. You could face regulatory violations, which are board complaints. You could place malpractice claims. You could face criminal prosecution for sexual misconduct. Oh, by the way, on the sexual misconduct issue, Texas even instituted a law that says if a clergy person engages in sexual misconduct and the denomination knew or should have known of their proclivities, then the denomination is responsible, and they have a statutory rule in that. So it's not the kind of place, and they did that after the Roman Catholics had won a case down in Houston where a guy from Colombia came up here, and they sort of hid the fact that he had had problems in Colombia, and the MAS, who was employed by St. Thomas University, said, this guy's a problem, and the church didn't do anything about it. But they squeaked out on some technical issues, and also it was a few years ago. But so Texas, anyway, has got a statute now that makes it very, very clear. So here's what happens. If you're an MAS, the only way you say, how could I get sued? Well, you could get sued easily, but the plaintiff would be successful, and that's an interesting word. That means they win. They would be successful only if you had a duty to do something, you breached that duty, and because of the breach, there were damages. That's the essence of a tort litigation. And here are some of the duties you might have. Competence. You have a duty to practice within the bounds of your competence. So, for example, if you are interpreting psychological instruments and you could not demonstrate that you were trained in that area, then you would be practicing outside the bounds of your competence. Consent and confidentiality. In Texas and in many other jurisdictions, consent does not exist unless it is in writing. So a verbal warning is insufficient, and I would encourage you, anybody that does evaluations for the future, to make sure all of the nature of your consent with your candidates is in writing, and that they sign that. There are multiple provisions in both the APA Ethics Code, the Forensic Guidelines, and elsewhere that say you have to disclose the limits of confidentiality to a person who's the beneficiary of your services. So you might say something like, it's important that you understand that anything you say can be reported to the bishop or the board of ministry. And if you need an attorney, you're not entitled to an attorney because they're not going to help you anyway. But do you understand these rights as I've read them to you? You could very well say that, but you're going to say a lot of other things. You and I do not have a doctor-patient relationship. If I have a client here, it's the church. And so you tell the candidate, it's like the other day when I went in to see a phlebotomist, and they were drawing blood, and they missed, and I realized what they mean by practice, and they chose another arm, and then I'm thinking, I'm going to have to beg and plead to get a copy of this because the information is not going to go to me. It's going to go to my juice doctor, my endocrinologist, or my pump doctor, the cardiologist, or maybe even my plumber. You can guess about that one. But I'm not necessarily going to get this. So you need to be quite clear about what the rules are in that annual conference about who gets the information, how it's going to be shared, and the disclosure is very important. Now, there's also a principle called honesty and fair dealing. You have to be fair and reasonable. You have to maintain personal boundaries. I always used to say when we were teaching groups of psychologists or any mental health practitioner about legal duties, that if the only people with whom you could have an intimate relationship is your patient, get a life. issues about record keeping, and that needs to be spelled out. By the way, I think we have talked about it. If we have not, we will make sure that you do know. On the board website, there is a sample contract, because contractual relationships need to exist between an annual conference and a MAS that describe your duties, much as Florida has done, that describe the time frames in which you work, because someone will say, well, I don't get report back in a timely way. Well, that needs to be spelled out in that contractual relationship. Who is the owner of the records? I don't hold an opinion about whether the person who is the examinee is entitled to a copy of the records or not. That's a decision of the annual conference, and I'm not in a position to make that decision when I'm conducting an examination. If I were speaking on behalf of the board, I might have a position. Otherwise, I don't. The important issue is that you know what that position is, and it be disclosed to the person in advance. And also that you understand that by the way, in the paper that you will receive, that's I guess it's electronic, is it not? Right? It's not. Yeah. There's a long footnote that includes HIPAA guidelines, and essentially whether this is HIPAA protected information is up for grabs or not, but if not, it may well be protected under some other law having to do with employment purposes. But the essence of that is that the statement issued by Health and Human Services is that the individual provider must obtain the consent of the examinee to release the records. However, if they refuse to provide that consent, the employer would incur no liability from not proceeding any further. So you can say, you have every right to say, I don't want it sent to the annual conference. You understand that will very likely terminate your process of entrance into ministry. And that's and the law supports that. The law would support that, especially given that under the ministerial exception rule. They would support that in other areas as well. So, under the ownership of records, the MAS only owns the data that he or she generates. You do not own data that others generate. And your opinion. The church owns all the reports, and the clarification of that policy is critical. Again, access to the report is determined by policy of the annual conference, and the consent forms that we have drafted the committee's drafted, you can download them if you would like to use them as a model, provide both options. And you can check off which option applies to your annual conference. Records retention is pursuant to the law of the jurisdiction of the canonical law. Well, the law of jurisdiction for the MAS. In Texas, it's 7 years past the date of the last date you saw the person, or 3 years past the date of majority, whichever comes last. But in other states, it may be 5 and 5, and some is longer. But for the church, the data is maintained in the person's personnel file. Now, the discipline, I think it's 606, says that everybody has a right to the content of their personnel file unless they've waived that right. And if they waive that right, then they don't have content to everything in their personnel file, and you may maintain it. GCFA has very specific guidelines on the maintenance of records, and they have a legal services department, and you can chat with them about that. Excuse me. I want to make a quick comment about the behavioral health guidelines. Is there anybody in here that does not know about GBHEM's behavioral health guidelines? Anybody? You all do. Good. Because they include at least these items, and there's a standard, there's areas of inquiry, and there are recommendations associated with each area. Alcohol abuse dependence, chemical abuse, compulsive gambling, divorce or infidelity, family violence, interpersonal relationship style, legal general, legal sex-related crimes, mental illness, and personal finances, physical health, pornography, sexual misconduct, and an addendum on definitions of proper sexual conduct. Now, I'm going to finish this by giving an example of how that might be used. But my point is, that if you don't know what those are, you need to know them because they're areas of inquiry about which you need to be cognizant when you conduct an evaluation. Let me speak to an ethical issue. It's also a legal issue in some states. The APA would say in our Code of Conduct that you don't offer an interpretation of any person you have not seen. So blind interpretation of data without disclosing the limitations is patently unethical. Now, in many states, including Texas, it's illegal, and it would subject you to a board action. I do not know how many states that is illegal, but it is certainly would bring significant scrutiny upon you. Now, I speak about that because for years we've had folks who have promoted instruments and scoring instruments and doing interpretations without ever seeing the person. At the very least, you would have to say, well, this is kind of like reading tea leaves, and there are significant issues of validity associated with any interpretation of data. Now, I don't know that a board would love to receive that data, that information, if you put that caveat in there anyway, but you would have to do so too. So, incompetence. Persons provide only such services and render such interpretations of test data as they may be qualified by education, training, and experience. So if you're not qualified, the way you get qualified is you have continuing education, you do study, you get supervision, you take a course, and that's how you do it. Conflicts of interest. Well, that would be an issue that are going to get you some board problems. For example, if you have done therapy with a candidate, there are states like mine that would say you can be an evaluator or you can be a therapist, but you can't be both in the same case. Pay you money, take your choice. Or if it's your brother-in-law that you're evaluating, there's some consanguinity related to this person that would be not the person for whom you need to be conducting an evaluation. Then there's the whole issue of sensitive populations or ethnic and racial differences as related to test data and behavioral guidelines, and Mike has spoken about that. We talked about roles. One of the things that I didn't hear, maybe I just missed it, was that what we're doing, I did hear the issue about developmental. The kind of question you ask is appropriate to the point at which the person is presenting themselves. So that, for example, the issue of candidacy. We've historically said the issue of candidacy is an issue of fitness. Is there any obvious impediment to the conduct of ministry that would pose damage to a congregants, to the church generally, or to the person themselves? If not, the church has a wide tolerance for eccentricity. Well, look at me. I mean, I had my first church when I was 19 years old. Can you believe a DS doing that? Of course, I was in seminary when I was 20, barely. But you know, there are strange birds like that. But we can't go back and relive the past. But as Mike said, we don't do it that way anymore. But the issue for candidates is one of fitness. On the other hand, for commissioning, the issue is readiness. Is the person now sufficiently grounded in the Methodist and our Anglican tradition that you can distinguish yourselves from other branches of Christendom without rancor or hauteur? Are you comfortable in your own skin and you have beginning to have some idea of your longest and strongest suits for ministry? And when I say the church has a wide tolerance for eccentricity, I I didn't mean that particularly humorously, though it is. What I mean is that we have different gifts. And you might have done an undergraduate degree in accounting and worked to become a CPA and have a great deal of difficulty relating to people in crisis. But you might be a slam dunk to be a business manager in a very large congregation or work in the conference treasurer's office. Similarly, there are persons whose entrepreneurial skills are such that they can meet, they've never met a person they didn't like. That was a quote by somebody, as I recall. I think he died in a plane crash in 1937 with Wiley Post. I am not that person. Well, by the way, I am old enough to be that person, but that's another issue. I'm also not the kind of person that can easily go make cold calls. That would be difficult for me. But there are some people who can do that. I'm the kind of person who, as I already said, I've never had an opinion I was reticent to share. And it gets me by the way, I have never gotten in trouble for what I did in my life. I've gotten in a world of trouble for what I said. With final orders or a full connection, there's a different question altogether, and if it's done there. Now the issue, or later in ministry, it's also an issue of effectiveness, because by the time somebody gets to that point, they've been in ministry for a long time. So the kind of evaluation, if you were doing one at that, would be very, very different. You're probably not going to be interested in scale scores on some clinical instrument. The church already decided they want the person. The question is, what's the goodness of fit? Where do they work best? And how can we match their gifts and graces to the setting that's going to be where they're going to function best? There is, historically, there's been this conflict between examining and nurturing functions. I argue that at the candidacy stage, it is largely evaluative of fitness. And the examiner must never be unkind, but it is required that they be extraordinarily blunt, especially with the recipient of their information. Ooh. Here we go. That's one problem with getting old. You never know which button to push. I have this thing on my belt, this little device, and I don't know how to use it. I get a text from one of my children, and it takes 20 minutes to respond. So I push something that says, "Call me." I'm sorry, you know. The conflicting roles. Loyalty to whom? The church, the candidate, who's the client. Now, you as an MAS need to be very clear about that, and the church needs to be very clear about that. If you have problems with that, that's an issue. Reporting adverse information. What duties exist to the candidate? That's an interesting issue. It might depend on how adverse it is and what you may learn from that. For example, I can't imagine that this would apply in a candidate examination, but I'm a psychologist, and I did go to medical school, but I thought it was bright to get a PhD out. It shows you how stupid I was, and didn't get an MD degree. But nonetheless, I've only saved a couple of people in my life, saved their lives. I had a 42-year-old lady in my office once who was rather thin, sallow-complected, and had kind of a low-grade depression, and she was coughing a lot. And I thought, she's either got a vascular problem or she has CA. so I said, would you be willing to see see somebody as a consultant? And she's being followed by a well-known internist who was not happy about that later. But she said, well, okay. And so while she's there, I got on the phone and called a pulmonologist that I knew who was in the med center. And I'd say, I want you to go now. So we sent her down there. I get a call about an hour and a half later from this pulmonologist who said, I'm taking over to St. Luke's for surgery. I said, oh? She said, yeah, I did an x-ray because I was thinking what you were, that it might be vascular or it might be cancer. But she has a myxoma in her right atrium. Now, a myxoma is a growth sometimes as big as a small tennis ball, and it attaches to a stem inside the atrium itself. And the problem is, it blocks the pump. So the pump can't pump. And so she was experiencing shortness of breath because she was having a vascular crisis. And the pulmonologist said, if you hadn't gotten this lady to me, she would have died. Well, I can imagine all kinds of weird things that you may see before you that would require that you share information with a person or that you do something other than just what may come before you psychologically, but that may be an issue too. But you report things as you see them. Now, my position is you don't make recommendations. You just let the conference know what the issues are. I've seen very few people who were psychotic. I told the group that I'd seen somebody many years ago who had a history of bipolar disorder and had 2 hospitalizations. So I told the conference that in then the dollars of that time, that if they were to take him, that it probably would cost the conference between $1 million and $1.5 million during his tenure in ministry for them to care for him. They took him. And 2 or 3 years later, managed to find a way to transfer him to a different jurisdiction. And I'm not altogether sure that the bishop shared that information, which is why Sarah said that, if somebody transferred to our conference, we'd like to have an evaluation when they come in. That doesn't happen in very many places. Now, there is a necessity for truly informed consent. This is a third-party examination. That gets to the issue about, is it forensic or not? That's a very complicated question because there are some evaluations that are clearly therapeutic. They're sought by the person or some family members, but the purpose of it is therapeutic. No question about that. There are some evaluations that are clearly to assist a court in the resolution of a legal decision. For example, parenting. And a court may, in fact, appoint a psychologist to do a family evaluation. And by the way, in most cases, the family pays for that, and they pay the psychologist. Very common. Is that a forensic examination? Absolutely, because they're trying to resolve an issue before the court. Or there might be an issue in a civil case about causation. Was this person damaged? That might be factual, but was they damaged because of X, Y, and Z? And to the extent that your evaluation would assist in the resolution of that decision, that's a forensic decision. Or in the criminal sense, which is where I've spent my life, it might be an issue of competence to stand trial. And in my state, there are all kinds of rules around competency, and those are things I know in my sleep, so I spend fully half my time answering questions for courts across the state about competency. But that's a forensic issue. So are NGRIs, not guilty by reason of insanity, or mental state at the time of the offense. That's a forensic issue. On the other hand, there are decisions, for example, that may be related to a legal issue, but it's not a present legal issue. For example, a simple pre-employment examination. Now, there are a host of psychologists in this country who deal they deal with large corporations. And they may require evaluations of their employees. They're not statutorily mandated, like police officers have a statutorily mandated evaluation. However, it's merely that it's mandated doesn't mean that it's forensic. In Texas, those are not forensic issues because I wrote the rule. And, well, I drafted the rule and argued it successfully with our group in the state. And we specifically refer to forensic issues as related to a decision that is currently being resolved before a court. But it is a quasi-forensic issue because it is a third-party evaluation. There are a number of third-party evaluations. Schools do third-party evaluations. And in those cases, it's quite different. They're distinguished from traditional, narrowly defined forensic issues. Well, treater or examiner. I've already said, for example, if you're treating someone, that might preclude you from being an examiner. Because in a forensic context where third parties are involved as a client, the rights issues of clients are very different. They might not even have a right to refuse the examination. So in competence examinations, they don't have a right to refuse. We don't give an informed consent. We inform them, but their consent is not required. Because I'm going to be required statutorily to offer an opinion whether they agree or not. It's very different with the people you examine. If they have to give their consent because you're not going to provide that information to the prospective employer without. So who the client is and the rules that apply for that. So now I'm going to go quickly here. As a summary, there's no liability for the church regarding the candidate. There is exposure for lay employees of the church. There are liability for examiners of multiple levels. I'm going to give you an example of the behavioral health guidelines and just how these might be used. Here's the category: marital status. Standard: the candidate's marital circumstance must be stable. Critical behaviors: a divorce in the past 3 years, and a history of having been married more than twice. Exploratory questions: if a recent divorce, what steps have you taken to understand the nature of your own contribution to the dissolution of your marriage? What steps have you taken to move yourself through a healthy grief process? If there are multiple marriages, what steps have you taken to identify and deal with any dysfunctional patterns in intimate relationships? In either case, have you maintained fidelity in marriage? If not, what steps have you taken to understand your actions and decisions so as to safeguard current or future covenants? Those are examples, and here are the recommendations. If a history of divorce is present, the recommendation would be that at least 3 years shall have elapsed since the divorce prior to certification for candidacy or for continuance. If the candidate has been married more than twice, that at least 5 years, either in singleness or in a stable marriage, shall be required prior to certification for candidacy or continuance. In either case, and particularly where there's evidence of a candidate's infidelity, the board may wish to recommend or require a course of psychotherapy with a focus on relationship issues. That's just an example. I choose that merely as one example, but I would encourage you to look carefully at these behavioral guidelines. And those are recommendations. They're not cast in stone, a number from 1 to 10, but they are general guidelines that you may use to help identify how you deal with these issues. Okay, in the interest of time, I'm going to stop, and I'll try to respond to any questions that you may have. I've already primed some of you to throw rotten tomatoes at me because keeping people awake is hard. But I will duck. There's probably a mic around there someplace. Well, there's one over there, but he's sitting down.
Okay, so in the conference where I served just this week, a district committee voted to accept a person into the process of becoming a local pastor, going to License to Preach school, who has two felony convictions of sexual misconduct. A former lawyer, DA, who was involved sexually with a confidential informant, and a person who was also being prosecuted in his office. So we have done our work, the psychologist and myself, I'm the conference pastoral counselor, to advise against that. I have rallied against it. It's been a 7-year process of this guy who was appointed as a lay, or was serving as a lay supply person, to now moving into the process of local pastor. These behavioral guidelines don't give us much leverage as far as mandates, right? I mean,
They would recommend in this case, no. But they're not disciplinary.
right.
There is no protection for stupidity.
Exactly.
And you might
Exactly.
remind the conference that they better take out a much larger insurance policy, but be prepared for the fact that it would not cover misconduct.
I know that, the lawyer knows that, but the district committee unanimously accepted this person.
Now,
into-
when help me, because I'm having a memory defect. I do that a lot. When do they become under the aegis of the Board of Ministry and not the DCOM?
Always. The DCOM is a subcommittee of the
Okay, then has the entire board voted on that issue? In this case?
No, they wouldn't even know about it in our,
They wouldn't
in
know
our
about it?
case.
Oh, that's interesting.
So the district committee has the authority, and the judicial council has told us this. It is the district committee's responsibility to certify or discontinue certification. However, it is the board's responsibility to approve the DCOM's recommendation for licensing.
But they still would know.
So if they don't know it, I mean, I don't know if you can make it work, so they might know it. But DCOMs are subcommittees of the Board of Ordained Ministry, and licensing must be approved by the DCOM to the Board of Ordained Ministry to the clergy session.
Okay. Any other questions or comments?
Have you consulted with your conference chancellor?
She said yes. By the way, if it were me, let me tell you what I would do. Why not? I would consult with the conference chancellor, as I have, and I would see how this is handled, and I would arrange for a meeting between you, the conference chancellor, the examiner, and the bishop.
So last week, I attended the Do No Harm conference, and in relation to sexual misconduct there, we had insurance people there, and a very similar question was raised. If something happens and the church gets sued, the insurance company is first going to look to see if you had knowledge of a history of risk. And if that shows up in someone's file, the claim's not going to be covered.
Right, we already have to call the insurance.
Right. Right, so and there are a number of problems here. Yeah. Cammie, you have a different
Who's
question?
back here in the corner? You have to push the little button that says on.
You know, I just figured that out.
I'm slow, but I'm old.
Well, actually, it's connected to, my question's connected to here as well. In our conference, we have a youth minister who was a candidate for ministry, also made a local pastor, had a sexual misconduct thing happened in his church with someone who was a counselor, found out there was more people in the congregation that were adults that he was involved with and he was married. So we took him out of the process, but because my question has to do with if he goes to another conference or another jurisdiction, we know this, but we don't have a place to place the report. Okay.
Right.
Yes,
So-
but how do you know
speak
that
up.
if he doesn't tell? So the question, the response was, the person has to start the process in the new place, in the place that they ended it. And you're the one that, and that is disciplinary. But my experience of this particular person is they just will move to another place and start fresh again.
And that's where Cares is our denomination's friend. Because if they try to enter again into Cares as a new candidate, that will get caught. And we will go back to the original conference to see what the history is.
Unless they just want to be a lay employee.
Yeah, now we can't stop that, right? But Cares will catch if they try to start candidacy again.
Okay.
I earlier said there's no protection for
Cares is the
stupidity.
denominational standard. Everybody's required to use Cares, and yeah.
There's also no protection for masochism on the part of the church. I mean, subjecting yourself to knowing full well what the probabilities are is peculiarly self-destructive.
Right. Right.
I remember.
But, and this is where I think we need to do our background checks
Yes.
and references for the last place, that if they disclose where they have actually served, and that's part of, I think, what happens. So
It will vary by conference process.
yeah, so
Yeah.
I guess I wanted to know legally, could we put something in UN Cares that says discontinued, and make a note of, inappropriate behaviors or whatever, or is that a legal issue?
Nobody's going to touch that issue. The church can do whatever it wants to do.
Really? Okay.
Which, by the way, is a little troubling because we could also do some really dumb things. But
Yes,
in this case, they would not be in that category.
What GBHEM recommends is any time a clergy person is discontinued involuntarily, is that does go into the personnel supervisory file with the reason why. If they were to transfer to another conference, try to serve as clergy again, that file can be transferred to the new conference for evaluation. If the originating conference chooses to bring them back in, it's so critical to keep those notes in the personnel and supervisory files. Cares stops with certified candidacy, so we don't have a record of what happens once somebody is a clergy person. So that personnel supervisory file becomes very critical.
Anything else? Go.
No, they covered it.
They covered it. Oh, okay. Cool. Well, one down here. Yep. There's one back there and one down here. Sarah?
I just had one suggestion regarding the issue that you raised about the inappropriate decision the DCOM made. Because the DCOM is a committee of the board, one of the practices we have in Florida is that any decisions made by DCOM is then voted on by the Board of Ordained Ministry. So every time the board meets, we have votes that come to the board. So,
See, we don't have that.
yeah.
They say they.
So that might be a practice that you could propose, because then you can bring that to their attention that this was perhaps an inappropriate vote. So, every license that's recommended by DCOM is then voted on by the Board of Ordained Ministry and then again by clergy session.
So work with your boards. DCOMs are subcommittees, and there should be a liaison member between the board and every DCOM. So that's how the structure's set up in the discipline if conferences follow that structure.
They are, and I can find that and cite that. It's in
Don, did you have a question?
This question is about the ethics and liability. Can you speak a little bit more about what kinds of consequences or what the liability is if there is an ethical violation or if an MAS is practicing in an incompetent manner? Something.
Typically,
can you speak a little bit more about that?
The question has to do with what would be the consequences of ethical violations of practicing beyond the bounds of one competency. Typically, these are handled by board intervention, by board rules. Now, it can be quite expensive for you to choose to fight that, but the vast majority of board complaints are handled by agreement, and they result in supervision or continuing education, and the vast majority, in fact, are inadvertent. That somebody blunders into things more often than they do quite intentionally engage in misconduct. Now, we're not talking about some gross violations.
I'm talking about more if a candidate says, this MAS didn't evaluate me competently. Not that there was any sexual misconduct or anything like that, but that this evaluator or this MAS didn't do the evaluation to standards of competency because they didn't use this or didn't do this practice.
There is an association of state psychology boards, and their processes for handling complaints is remarkably the same throughout the country. There is an investigatory process, and typically the person charged will submit every item of information that they obtained in the course of their evaluation. A third party will be chosen anonymously to review all of those materials and write an opinion to the board about whether or not there's any evidence of misconduct. Now, many of those don't even get that far, but if it looks like there might be something there, the board may choose to do that. But the kind of thing you're talking about are typically relatively minor infractions. It becomes more troubling when, let's say, it involves a breach of confidentiality, because that might then result in a civil lawsuit in addition to whatever board action takes place. Does that make sense?
Yes.
Anything else? One more. Hey, guys. Thank you very much. I appreciate it. You can talk to me about anything. You can email me about anything. You can Google me on the net. You'll get 500,000 hits, most of which is chaff, very little which is sweet. But
Okay. Thank you, Floyd. So, as we break for dinner, Floyd, if I could ask you just to stay up here for just a minute, and then Tripp is going to set up what we're doing for us this evening.
Thanks. How many of you are familiar with a special call general conference in 2019? I mean, we snicker, but there's maybe some people in here that aren't familiar with that kind of thing. Can you raise your hand if you are? Okay. Okay. What we're going to, raise your hand if you're not, if you have no idea what I'm talking about.
So there are some folks.
Okay. The 6,000 mile per hour flyby of general conference process. Every 4 years, the church gathers together in one place to kind of talk about strategize on how we're going to live together as a connectional church across the globe, long story short. In 2016, we met. In 2020, we'll meet again. But in 2016, the conversation around human sexuality in the church became really complex. It always is, but it was very complex in 2016. And so they decided, the Council of Bishops decided, we're going to have a special general conference. We're going to bring everybody back again just to talk about that issue. And that's going to happen in 2019, in February, in St. Louis. And they put together a special commission of 30-ish people, 32, I think, people from all over the place to talk about some recommendations and how we might be able to kind of move forward as a church around this issue. So they've put together different plans, and they've met for a while. What we're going to hear tonight are from two members of the commission, and they're going to talk about their work and how that went and how the recommendations came about and things that might happen in 2019 that influence how candidates engage with the church and how the church can engage with candidates, because it's going to impact how people are coming into the church and how the church is going to engage those that are still out there. It's Jessica LaGrange and Alice Williams. So Jessica from Kentucky and Alice is from Florida. So any questions about that? I know on the schedule it says 7:15 and there's no end time. There will be an end time, okay? Because I'm tired. And we will eventually wrap it up. We just didn't want to go for an hour if you guys only wanted to talk for about 5 minutes about it. And we didn't want to shut it down in 5 minutes if you wanted to go on for an hour. So it will go as long as you have questions or until I become really, really tired, and then we'll just shut it down.
Yeah, and this is done in an effort to help you understand some of the macro issues that are going on with the United Methodist Church right now. One kind of cleanup piece, Floyd mentioned the personnel and supervisory file guidelines, and those are in the BOM handbook. They're Chapter 25, and those are put together by General Counsel on Finance and Administration, GBHEM, and Westpath Pensions and Health Benefits. And on that same BOM library you've been looking at all day, just go to the BOM handbook, Chapter 25. They are there. Floyd, I would like to ask you to come back up here, please, for a moment. I think one of my favorite lines in Floyd's presentation today was that he's never had an opinion that he's reticent to share. And he's a delight to work with. And I would like to also invite the members of our ACCA committee to be present. So Floyd began work on the ACCA committee in 1983, 35 years ago. Floyd is one of those people that I can call at 2 or 4 or 6 in the evening with a critical question, and he gets back in touch with me as soon as he possibly can. He has written judicial council briefs that have helped us better frame the work of candidacy and clergy relations to the General Conference. He's done many, many hours of work behind the scenes and at events like this. And Floyd, we wanted to recognize you today and show our appreciation for all the work that you have done for the United Methodist Church. So, we argue about the name of the committee, but I wrote the certificate, so I get to name the committee. So, we are wanting to appreciate you for distinguished service as a member of the Advisory Committee on Candidate and Clergy Assessment, countless hours of expert consultation to support and strengthen the work of the Division of Ordained Ministry, boards of ordained ministry, candidates, and clergy throughout the United Methodist Church. And I wanted to present this to you on behalf of the General Board of Higher Education and Ministry, Kim Cape, our General Secretary, and all of our staff, Board of Directors, and constituents. We also have for you, this is a bronze medallion, which is a replica of the bronze marker that hangs on the front of the General Board of Higher Education Ministries building. And it shows it's some images that commemorate the work that we do. And we had replicas made in honor of GBHEM's 150th anniversary, and we want to present this to you as a symbol of our appreciation. Thank you.
You have no idea how much this worries me. I'm not sure if it means it's posthumous, I already died, or that it is a gentle out and a signal thereunto. My cardiologist had me evaluated for a heart transplant. They said I was too old, and he said that was dumb. So he said, well, just ride this horse until it bucks you off. So I'm a little bit active. I went in for this evaluation, I'll tell you this real quickly, and the social worker and psychiatrist were doing evaluation, and everybody looked ill that was there, and I was in my usual uniform, and they said, who's the patient? And I said, I am. And they said, Well, first, sir, do you have any problems with your ADLs, your activities of daily living, dressing and toileting? I said, my staff thinks my ties are too bold. And they said, your staff? I said, yes. Do you work? A little. How much? I said, I try not to work more than 60 hours a week. And there was a long pause after that. So I don't know what this portends, but I'll hang around as long as they'll have me. So thank you all very much.
And Guy Seymour is going to honor Floyd and close us out with prayer. Dinner begins at 6, and we come back at 7:15 tonight. Guy.
I want to say that Floyd Jennings is the reason that I've been on this committee. And I've been here 21 years. I don't expect to be here another 21 years, so Floyd, you might be. Let us pray. Dear God, we give you thanks for the opportunity to engage around the tasks of assisting others in discernment of your will for the church and for its future leaders. We know that the Spirit is with us and within us and guides us in the use of our gifts of mind and effort. And for this we thank you as we have engaged in the dialogue of today. And we thank you as we anticipate the food for our bodies and the further food for our mind and our spirits for the rest of this day. Amen.